My name is Steve Devereux. I have completed over 50 appointments as arbitrator and expert witness. Many of the contracts I have read have had deficient arbitration clauses. In most disputes this doesn't cause a problem, but it can. A few had pathological clauses which made it impossible to form a tribunal without the agreement of both the parties, and also made it impossible to litigate in most jurisdictions. You would be stuck and unable to resolve your dispute. These deficient clauses were boilerplate text used many times for other contracts, sometimes for many years. One referenced an institution that had never existed. The name was similar to an institution that used to exist but closed years before. The arbitration clause is the least important clause until you have a dispute, and then it can become the most important clause. A badly drafted or old arbitration clause can end up costing a lot of time, money and management effort. I attended a webinar about the recent Singapore case of Mittal v Westbridge Ventures. This prompted me to record this video, which is aimed at in-house counsel who prepare contracts and appoint arbitrators. This short video is not detailed legal advice. It gives you some things to consider. In particular, don't reuse old clauses, but draft the clause for each contract with proper advice from a lawyer experienced in international arbitration. The first choice you must make for the arbitration clause is whether an arbitration will be administered by an institution, such as the International Chamber of Commerce. An arbitration can be done without using an institution. These are known as ad hoc arbitrations. An institution will offer an appointing authority so that if the parties cannot agree on the panel members, the institution can provide that service. If you go for an ad hoc arbitration, an appointing authority can be chosen. There are plenty of institutions with their own rules, services and costs. An institution is a business, and some of those businesses charge a very high price for their services. The ICC charges a percentage of the value of the claims, which isn't related to the amount of work that they actually do, similar to an estate agent selling houses on commission. An ad hoc arbitration can use any rules they want and can modify them in any way. While ad hoc can cost much less than institutional, it requires a competent person or team to manage the necessary functions. In law, an arbitration clause is separate contract within a contract. It will survive termination of the host contract. It can have a separate law applied to it than the law governing the contract. A contract could be under Indian law, but the arbitration agreement could be under the law of England and Wales. The law of the arbitration clause, called the lex arbitra, may govern the arbitrability of the dispute. It is very important that the arbitration agreement defines the lex arbitra. Some jurisdictions like the UAE impose conditions on who can sign the arbitration agreement, that is, the level of authority in a company, so check this as it could spike your agreement if the signer does not meet that condition. The seat is the legal home of the arbitration. The law of the seat, called the lex fora, will govern the arbitration itself, the resulting award, enforcement of and challenges to the award. The courts of the seat can be called on to assist the arbitration. Public policy at the seat can dictate what can be arbitrated. The express choice of the seat is one of the most important parts of an arbitration agreement. If left undefined, the tribunal may determine the seat, and that might not be optimum. It's better to make this a carefully considered choice within the agreement, rather than have it imposed after the arbitration starts. For international arbitrations, it is essential that the seat is in a country which is a signatory to the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. It should also be in a country which is supportive of arbitration and where the types of dispute that might arise are arbitrable. The seat is the legal home, but the arbitration process and hearings can be held anywhere. The lex arbitra and the lex fora should be the same. Both should be defined within the arbitration agreement to make it explicit. Choosing different laws for the agreement and the seat can lead to uncertain outcomes. The arbitration agreement can define how a panel of 3 arbitrators should be made up. An appointing authority is obliged to follow what the arbitration agreement requires. Most international commercial arbitrations have 3 aspects: legal, industry and financial. It makes sense that an efficient tribunal would include these three areas of expertise: the law of the contract, the subject matter of the dispute, and financial. Your arbitration agreement could specify that the tribunal comprise a lawyer familiar with the law of the contract, an industry expert, and a quantum expert or accountant. Your agreement could specify that arbitrators must limit their number of concurrent tribunal appointments to 4 or 5 during the arbitration. That would give a functionally diverse panel with the time and skills necessary to handle the case efficiently. Think about how the tribunal should be constituted to optimize the skills needed for the type of dispute that might arise. The agreement can also dictate a time limit to produce the award. The ability to choose your arbitrator is a major advantage of arbitration compared to litigation. This should not be delegated to an institution. Some institutions only appoint lawyers even when asked not to. Some appoint from a few favoured arbitrators. The only way to guarantee to appoint an arbitrator who fits the needs of your case is to be fully involved in that choice. In too many international arbitrations, some or all of the arbitrators have so many appointments that they do not have sufficient time to give to each case. There are some arbitrators who will limit their number of concurrent tribunal appointments to avoid this. Awards often take far too long because the arbitrators are too busy. I am happy to limit my number of concurrent tribunal appointments to 4, knowing that I can commit the necessary time to produce an award within a reasonable time for up to 4 cases and still have time to enjoy life. In this case, a shareholder agreement was made under the laws of India. The place of any arbitration would be Singapore. The appellant, Mr. Mittal, filed a lawsuit in India based on alleged corporate oppression of minority shareholders. The respondent followed that with an anti-suit injunction in the High Court of Singapore to stop the appellant's suit in favour of arbitrating the dispute. Mr. Mittal argued that the law governing the arbitration agreement was the same as the law of the contract Indian law, although this was not specified. He argued that the subject of the dispute was not arbitrable in India. The dispute pertained to claims under Indian law, that the Indian courts should decide the case, and the injunction should be set aside. Westbridge argued that the dispute related to the exercise of contractual rights, and the contract required all disputes to be put to arbitration in Singapore. The law of the seat should prevail and the injunction granted to force arbitration. The question the court had to answer was, which system of law should govern the question of claims at the pre-award stage, the law of the agreement or the law of the seat? The Singapore High Court found that the disputes were arbitrable under Singapore law. Mr. Mittal had breached the arbitration agreement, and even assuming Indian law governed the agreement, the disputes fell within its scope. The judge did not decide what the proper law of the arbitration agreement was, just that it wasn't relevant. The permanent injunction was granted. Mr. Mittal appealed to the Singapore Court of Appeal on 2 alternative grounds: that the disputes do not fall within the scope of the arbitration agreement, and that the disputes are non-arbitrable under the law of the arbitration agreement, which should be Indian law. He also asserted that any award would not be enforceable in India. The Singapore Court of Appeal applied the 3-stage test to determine that the proper lex arbitra was Singapore. The disputes were arbitrable. The injunction was upheld. Costs awarded against Mr. Mittal were $100,000. The best way to avoid problems is to explicitly define the same law for the agreement and the seat, which should be chosen after expert legal consideration of issues of arbitrability, court support, New York Convention signatory, public policy, and other relevant issues. If different laws applied, public policy of the lex arbitra can be considered by the court of the lex fora when considering arbitrability. A Ukrainian company, Comstroy, formerly Energo Alliance, commenced an arbitration against the Republic of Moldova over a large unpaid bill for electricity supplied to Moldova. The Comstroy v Republic of Moldova arbitration was between 2 parties who were not within the European Union. Unfortunately for the claimant, Comstroy, the seat of the arbitration was Paris. The tribunal awarded Comstroy almost $47 million under the Energy Charter Treaty. Moldova appealed to the French courts, who referred questions to the Court of Justice of the European Union, CJEU. The result was that the award was annulled after intervention by the CJEU. Two non-EU parties had their arbitration award annulled by the French courts, who are subservient to the CJEU. Other cases where investors were denied awards by the diktat of the CJEU include Achmea and Mittal. A court in Switzerland in the case of EDF versus Spain found that the CJEU judgments ignored international law and did not affect the provisions of the Energy Charter Treaty, which has many non-EU based parties as signatories. The key lesson is for contracts to define a non-EU seat of arbitration within any arbitration agreement, the lex fora, and to also state that the law of the arbitration agreement itself, the lex arbitra, to be the same as the lex fora. An example sentence within the arbitration agreement could be: any arbitration shall be seated in, name a non-EU seat, and the law governing the arbitration agreement, the lex arbitra, shall be the same as that governing the seat, the lex fora. I hope you found this video useful. These links download the IBA guidelines and the judgments in Mittal v Westbridge Ventures and Dalla v Pakistan.